Good afternoon. Thank you all for coming. I'd like to welcome you to the first spring event in our Practical Politics and the Law speaker series, sponsored by the Program in Public Law, and I'd like to recognize Professor Chris Schrader for his generous support of our activities, and the Duke Journal of Constitutional Law and Public Policy. Last fall, we began this series with the hope of introducing Duke Law students to the variety of options that we have for our future engagement in and legal practice in the American political process. And our speaker here today very well illustrates a different model of political participation than we've had in our previous speakers. Mr. Ben Ginsberg is not known as a candidate for political office. Instead, he's one of the leading practitioners of a type of legal practice that's long existed but is rarely acknowledged, the political lawyer. His experience as an advisor to candidates, campaigns, and parties is both deep and broad. He served as chief outside counsel to the Bush-Cheney campaigns in both 2000 and 2004. He's represented leadership PACs of numerous members of Congress and works with the National Republican Senatorial Committee and the National Republican Congressional Committee. In addition, he's advised independent 527 political advocacy groups such as Progress for America and SwiftBoat Veterans for Truth. And finally, he has also served as chief counsel both to the Republican National Committee and to the Republican Governors Association. In addition to these formal positions he's held, most prominently for our purposes here today, while he was serving as counsel to the Bush-Cheney campaign, Mr. Ginsberg played a key role in coordinating the Republican efforts in the Florida recount during the 36 days that followed the 2000 election. It was in connection with this that I originally asked Mr. Ginsberg to speak with us today, though I'm certain he'll share with us something of his broad range of experiences as a political lawyer as well. Hopefully these will include some of his experiences with redistricting, for instance, in which he played a key role in organizing the Republican efforts at the 1990 redistricting cycle that led to the 1994 Republican Revolution in the House. I hope that you will join me in offering a warm welcome to Mr. Ben Ginsberg.
Thanks, Ryan. Well, thank you, Ryan, and thanks very much for having me down here today. It's always great to come down and talk about politics, and especially to law students, because one of the natural things that comes with law school is not necessarily being able to be involved in politics on a regular basis. But public service is obviously important to the country as a whole, and I have to tell you there is nothing more fun than being involved in campaigns. They're not only important, but they're also really extremely satisfying personally to be able to go out and work for candidates who you support, whatever their stripe may be, and to be able to lend the particular talents that you have either as a lawyer or as a normal human being, and to be able to get people who you believe in positions of responsibility, making decisions that affect everybody in the country. With a law degree, you have a particular ability and a particular set of skills that really is awfully valuable to campaigns, not only for the legal work, but also just for kind of the way you think and the way you do research and the way you learn how to communicate for the most part. But I really can't urge you enough to get involved in campaigns and to participate in the process. Out of curiosity, how many of you have been involved in campaigns on some level? Oh, that's great. So I hope you know what I mean by the joys of working for campaigns. I've been lucky in being able to sort of blend a law practice into working with campaigns, and what I'd like to do is tell you a little bit both what that in practice entails and also sort of how it came to be to the extent that I can actually understand that myself. I kind of went through law school, and one of the reasons I like doing speeches like this is that I can remember sitting there as a second and third year student with some idea of what I wanted to do, but absolutely no clue how to get there. And I promise you I was sitting back there in the back row, so I feel a particular affinity for all of you back there. And that's not one of the things that naturally comes from being in law school or being a law student. But it's one of those things that can happen. And what happened to me was really a tribute to sort of serendipity as opposed to careful planning, but it can happen. I had no idea what I wanted to do when I got done with college. And law school seemed like not a place I should be right away. And I did what I enjoyed doing in college, which was being a journalist and being a reporter. So I went from being editor of my college newspaper into the field of reporting. And reporting was a great way to cover politicians, among other things, but also to see various parts of life, various government programs. My first job out of college was an internship on the Boston Globe in the summer of 1974, which was noteworthy not only for Watergate, which was completely immaterial to my life, but for the summer that they started forced busing in Boston, an interesting notion of a government program applied to real life. Now, the Boston Globe is kind of a parochial organization, and although my last name is Ginsberg, I had red hair, and so the guys who ran the Boston Globe assumed I was Irish and stuck me on the streets of South Boston to cover the riots in the neighborhoods. And that was kind of an eye-opening experience in terms of government and people and well-intentioned programs that maybe don't work quite exactly right, which provided sort of an analytical tool for the rest of, I get searing memories of things from that, from watching an experience like that take place. I then went to a small town paper called the Berkshire Eagle in Western Massachusetts, which was an opportunity for a city kid to see small town life. And again, politics and social structures in a town like that really kind of helped put in context in later years what the practice of law was. And I stayed there for a couple years, got thoroughly bored with being in small town life, and moved out to California to work in the Riverside Press Enterprise, the Inland Empire, the spot in the country where the smog from Orange County and the smog from Los Angeles sits. It's a lovely spot, but it was also the fastest growing community in the country at the time I was there. And that rapid growth brought to the forefront all sorts of interesting issues. And I realized I had no idea what those interesting issues were, but they had to be out there. And I was really overwhelmed by my ignorance when I saw permits for 100,000 new homes in this one area go before my eyes in 6 months and had no idea what questions to even ask to be able to put it in a real context, which is what led me to law school. And law school I found to be one of those experiences where I sat in the back row all the time, but nonetheless learned a series of skills. I really didn't know what I wanted to do, although I still had this sort of fascination with politics, but I knew I was a reporter, and I got a job doing libel defense work at first for a firm in Washington, which was good because it let me sort of capture my roots as a reporter and put it to some sort of practical use as a lawyer. You may find when you go to work in a law firm that there are certain partners who have particular personalities. And sometimes that's good, and sometimes it's not so good. And one of the political realities of law firms is you got to work for more than one partner sometime. So I sort of ran into these guys who were doing election law work. And so in sort of the classical serendipitous happenstance, the hours churning exercise I got as a first-year associate in a law firm was to write a memo for our client, the Republicans on the House Administration Committee, on the history of recounts in the House of Representatives. And so I spent a large number of blissful hours researching this great stuff, billing lots of time that made the partners happy, wrote what I thought was a wonderful report on the history of recounts in the House, and that was 1982, and nobody even looked at the thing the whole time. 2 years later, however, I dusted it off, And lo and behold, in 1984, there was a recount in southwestern Indiana called McIntyre versus McCluskey that ultimately was decided by 4 votes. But the day after the election, when everyone was scrambling around trying to figure out what you do if there's actually a recount in the House, I was the little kid who actually knew the answers to that, miraculously enough. And so there, sort of in a complete bit of happenstance, was born my career as an election lawyer. I went out to Evansville, Indiana for 6 months in the middle of winter. My wife and I had just had our first child. The difficult political atmosphere of dealing with Southwest Indiana contentious recount paled in comparison to dealing with having a 6-month-old child at home. But nonetheless, the recount went on. Republicans lost that recount. The Democrats in the House of Representatives decided that they just had to have one more seat to try and put Republicans in their place. I remain convinced to this day it was a stolen election. It turned out being by 4 votes. It was, in retrospect, the event that galvanized a very sleepy Republican minority in the House of Representatives into taking a slightly more militant approach to politics in the House of Representatives. One of the people who at the time in 1984 was just a backbencher but was thoroughly outraged by all this was one Newt Gingrich from Georgia, who took that feeling that Republicans in the House had and pressed it into a real change of attitude that ultimately, I think, led to the Republican takeover in the House in 1994. But that was the first time that I had actually seen lawyering and litigating coming out into sort of a conjunction. Because in a recount, I discovered what happens is that you have to mix a lot of political law with a lot of litigation. Again, in the best spirit of serendipity and not being able to plan much of anything, I got back from that recount and prepared to go back to being a 3rd-year associate in a big law firm. And as luck would have it, the in-house counsel at the National Republican Congressional Committee, the organization which really sponsored our work in the recount, left. And so there I was saying, that'd be a fun job. And they said, gee, we know you. Would you be interested in the job? And so I was balancing being a 3rd-year associate in a law firm with being the in-house counsel at a political campaign committee, and that took about half a second to decide. And so I went inside to become the counsel to the House Republicans. I did that for 2 really fun-filled years. It's a great opportunity to be able to represent members of Congress and candidates and all the issues that they face. After 2 years, there was another recount, and recounts really do change lives. But there was another recount in Minnesota that I participated in. Lo and behold, the Minnesota senator, who put a lot of people into that House recount to help his colleague, was taking over as the head of the National Republican Senatorial Committee. They asked me if I wanted to do that job. I figured, great, 2 years in the House, 2 years in the Senate, before I go back to the somewhat duller practice of law. I think I'll do that. And so I went over to the Senate for 2 years. Again, a different institution, but really a great and unexpected opportunity to be able to see the U.S. Senate in operation. That cycle ended in 1988, and I was fairly convinced that I would end up going back to my law firm, having done 2 years in the House and 2 years in the Senate. And the day after Thanksgiving, somebody I worked with came to me and said, gee, I just had Thanksgiving dinner with this woman named Mary Madeline. She's about to go take over the Republican National Committee as the executive director, and the chairman's going to be Lee Atwater, and they want to interview you to be at the RNC. And I thought, well, okay, let's see what this turns up. I had known Atwater a little bit over the years, and I go in to interview with him at the transition headquarters in 1989. The first President Bush had just won election. Atwater was the campaign manager who ran that race. I go into this windowless room in this sort of impersonal office building in Washington, and there is the great Lee Atwater with his feet propped up on a desk with a book of great grade B movies of our time that he's reading. And he goes, well, I kind of know you. What I really want to know is what you think of Pia Zadora, who was truly one of the worst actresses to ever grace the silver screen. And so Atwater and I spent 20 minutes talking about Pia Zadora and John Waters movies. I didn't even know I knew that much about him. And he said, well, you're okay. I just got this one thing. It's called redistricting. And I hear you're smart, and you're going to have to do something smart about that, and I'm going to hire you. So he hired me, and that was when redistricting was starting. Now, at the time, there I was, sort of a young election lawyer walking into the RNC. Republicans had been a minority in the House of Representatives and virtually every major state legislature since the mid-1950s. And as redistricting works, once you lock in a majority, it's real hard to get the maps redrawn in any sort of a way that a minority becomes a majority. And so we were sort of looking for the silver bullet at that point. And the silver bullet turned out to be the Voting Rights Act. Now, the Voting Rights Act was a reform put in by Democrats in the mid-1980s to create what they felt were more equal opportunities for minority voters. And the whole redistricting process quickly became known as the food fight process, because what Democrats had successfully done for the previous 30 years was to take minority communities in the inner cities and draw pizza pie slices out into the suburbs and then out into exurban areas that tended to be more Republican. And the result was not many minority representatives and a whole lot of white liberal Democratic representatives. And if the Voting Rights Act was enforced, it would force Democrats to draw donuts instead of pizza pie slices. And in reality, as a political reality, if you drew donut districts and kept communities whole, then that would result in more Republicans being elected and more racial minority groups being elected and fewer white liberal Democrats who were neither being defeated. And that was a very interesting process to go through, because the truth of the matter is that the Republican Party as a group does not believe in sort of racial quotas, racial politics, and looking at people through a race-based criteria. However, that theory was a politically helpful theory to gaining more Republicans and racial minorities elected. The Justice Department at that time decided to enforce the Voting Rights Act quite literally, and so to insist on the drawing of those racial minority districts. And at the RNC and really in state legislatures across the country, Republicans took advantage of that and complied with the way the Justice Department was interpreting the law. And despite that sort of internal philosophical debate in the party, litigated a number of voting rights districts in conjunction with racial minority groups. The result in 1992 was the pickup of about 10 Republican seats in the House of Representatives, not enough to take over the majority. That was the year that Bill Clinton beat George W. Bush, but there was litigation in probably 20 different states around the country, a real blend of political law and litigation that was really fascinating to go through, a fascinating cast of characters. There is nothing in the human sort of play of life that is quite as intense as members arguing over redistricting. No, I want the airport in my district. Besides, you got your mother and yours and the golf clubs going in between us, and so somebody's got to be sure to get the baseball stadium in his or her district. And it's really an intense and fascinating thing to watch from the inside. The result was Republicans made a pickup in 1992, And then in 1994 came the contract with America, an off-year election, Bill Clinton in the White House, and Republicans swept to victory and picked up 53 seats in that election and haven't let go since. And it was the sort of master print that was created from the new maps in 1990 and 91 and 92 that allowed Republican ideas to take root in more competitive and favorable districts. And so a blend of political law and election law, still very tightly contested, but nonetheless fascinating. We'll get back to redistricting in a minute too, because it's still very much a part of it. But when 1992 ended, I went out, had 2 kids by that point. It was time to sort of get serious about life. And I went into private practice and tried to become an election lawyer, a campaign lawyer, a political lawyer. The truth is, standard campaign lawyers' work, what we do on a regular basis, is really like being a general counsel to any startup company. If you're working for a political campaign, you go up and down in about 18 months. And the amounts of money involved vary, but the issues are all pretty consistent. There's a lot of time spent on the legal ways to raise money, either under federal law or state law, depending on the race. You've got a lot of contracts and employment issues and insurance issues, and how do you pay for the rock band to come in to do a fundraiser concert, and gee, we got to lease an airplane. What does it involve, leasing an airplane? And the answer to that is quite a bit, and find an associate to do that if you can. Communications work, you got to get the disclaimers right. There are always questions about whether the people you put in ads have signed the proper releases, so you don't find out kind of late that the person's a government employee and not able to actually appear in ads because of the Hatch Act. Permission to film various scenes and various people. We also spend an awful lot of time these days dealing with the new means of communicating in campaigns. And make no mistake about it, the way that campaigns get out their messages to people is changing rapidly in this new environment. When I sort of started out, you bought TV time on the 3 networks, ran a little radio, and that was kind of it. What the last campaign especially showed is that the new media, what frankly all of you think of as a matter of course, but people a couple of generations apart from you are still not totally comprehending, is that network TV is really fading as the main medium. And if you're going to advertise on national TV, there's now data that allows you to very much know who is watching what shows. And so you're very careful to spend money on certain programs where your voters are going to be watching the shows, and not spend your money on shows that your voters aren't watching. For example, Democrats watch late night television. So for Republicans to advertise on Leno makes no sense. Republicans watch crime CSI on a regular basis. Don't ask me why. And so you'll see Republican ads appearing on those sorts of shows. But it's now very much of a science where those advertising dollars are spent. Of course, cable television is now a whole new area where people have to think about how to advertise. The laws are slightly different for cable, but the Bush campaign in 2004 advertised a lot on the Golf Channel and on Home and Garden TV, where the data showed Republican voters are watching a lot. Not so much on O, that was more the Democrats, but we very carefully sort of figured out where our voters were watching, and you're going to go about trying to motivate your base, and it's a new world. And of course, internet advertising is still the sort of unknown gorilla waiting in the background to take over. It can be a great way to raise money. Nobody's quite sure if it's actually replacing the old ways or is a new source. It's a great way to mobilize voters, at least in theory, but Howard Dean had the greatest internet army ever up until the time voting started, and his army never showed up at the polls when it mattered. So does the political mobilization numbers that you get through the net actually translate into voters at the polls? An interesting question that's going to evolve a great deal, but again, it brings up a whole host of legal issues we never had to deal with before. There are also questions of ballot access, how you get your candidate on the ballot or the other candidates on legally, delegates to a convention in a presidential race, debate negotiations, truly one of the more fun and challenging exercises that a campaign lawyer goes through. And those are sort of the standard issues, and it really is being a general counsel to a small business with a short shelf life. In campaigns these days, there can also be bonus issues, and they're the ones that tend to involve litigation the most, and they're things like redistricting that I was talking about, recounts, which we all have come to know and love, litigation over campaign finance laws, and election day litigation, which of course has become sort of a huge obsession with campaigns since the Florida recount in 2000. Being lawyer for a presidential campaign is truly like nothing else, because while all the issues are sort of the same as on a local race, it's like they're on steroids. Everything is so much bigger. It's a 50-state operation. There's much more scrutiny that comes from it. The 2000 campaign was truly a joyous experience. Challenger campaigns are more fun than re-elects, by the way. But that was also in Austin, Texas, that for those of you who know, Austin adds a bit of joy to everyone's life on a regular basis. We went through the campaign, went through the debates, and thought we had done sort of our jobs. And of course, what happened in 2000 in Florida was sort of the bonus of all bonuses. The weekend before that election, we were all fairly confident that Governor Bush was going to become President Bush. We were up about 5 points in most of the key state polls. It of course, had this nasty little wrinkle in it on Thursday before the election when a story came out that when the president was considerably younger, he had been arrested for driving under the influence, something that had never come out before. The story appeared. He handled it quite well. We thought it had gone away as a factor in voting turnout. The campaign stopped polling on Friday, so there was no data to see, and we went cruising into election day thinking we were up. The day before the election, I took the folks who had worked in the legal office in Austin out for lunch to our favorite Mexican restaurant because the day before the election there really wasn't a whole lot to do anymore. And we were sitting around talking about lawyers' fantasies. That's not an oxymoron. You'll find that out. And the first fantasy we had that day was walking up the steps of a Supreme Court to actually determine whether your client was going to be the President of the United States. And we got a pretty big laugh out of that. And then somebody said, God, what if there was a recount before? I mean, you've done recounts, haven't you, Ben? And I go, yeah, I've done recounts. They happen every year in House races, maybe a statewide. And I said, with all the degree of confidence in my 20 years of practicing law, there will never be a presidential recount in our lifetimes. Something those people remind me of a great deal today, including the guy who is now chairman of the FCC who worked in our legal office that year, Kevin Martin. And so for some reason, when I try and lobby him, we just never get to first base on the issues now. At any rate, we went into election night, and election night is a terrible time because there literally is nothing you can do but just watch returns come in. And so as a lawyer, you answer the random phone call from some state about how an election is being stolen, and you put people on the scene, and it turns out to be drastically overblown, and you go back to fretting and waiting. And We kind of bided our time in Austin that day by going down to look at where the celebration was going to be that night. It was right in front of the Texas State Capitol, beautifully backlit, with literally an 8-story press platform built up behind it with television, hundreds of television crews from all over the country and the world there to sort of record the event. And we're sitting in headquarters watching the returns come in and, a little of this, little of that. And at 8:30 that night, the word comes out that Al Gore has won Florida. And that was truly about the most depressing thing you could possibly ever imagine to a campaign. The campaign was in something that looked like an insurance office with private offices ringing the side and common areas in between. As soon as that word came out, everybody scattered from the common areas and hidden offices. But people started looking at the returns, and the returns didn't look quite right. The returns and the projections seemed off from the exit polls. And Karl Rove, to his credit, got on the phone and started talking to the networks and jawboning them about what was going on. And sure enough, about 10:30, they kind of realized he was right and called back Florida and said it was too close to call. And that was like a shot of adrenaline through the campaign, as you can imagine. And so for the next few hours, it was states being determined with everybody in a pretty high state of anxiety the whole time. And I suspect everybody has his or her own memories from that election night. Mine is Tim Russert and that damn white chalkboard of his, where he's writing states on and off all night, till finally it's just Florida sitting there right in the middle. And then about 1:30 in the morning in Austin, all of a sudden the networks start calling Florida for then Governor Bush. And that's like a moment like no other. You've worked so hard for so long under such pressure, and all of a sudden your guy's been elected. And people are crying and hugging and doing high fives. And we go rushing out of the headquarters, 10 blocks up Congress Avenue, to in front of the stage to watch the victory speech. And it's a miserable night in Austin. I mean, miserable. It's 40 degrees. It's sort of misting. It's thoroughly uncomfortable. Nobody cared at all. And we're standing in front of the stage waiting for the soon-to-be president to come give his victory remarks. And we're waiting, and we're waiting, and we're waiting. And it's getting colder and wetter all of a sudden. And then, all of a sudden, on the big Jumbotron screens on each side, the lovely visage of Candy Crowley fills the screens. And she goes, "Give me a microphone, Al Gore's withdrawn his confession." And that is one of those, if you'll excuse the comment, a holy shit moment. Like, this can't be really happening. Cell phones start going off. We truck the 10 blocks back down Congress Avenue, fully aware of how miserable the weather is at that point, and deal with what's going on in Florida. And nobody can quite believe that you've reached that point about which you know history is written, that this has not happened since somewhere back in the 1800s. Nobody can quite remember when. And I remember kind of talking to my friends in Florida about what the results mean. Finally, about 3:30 in the morning, Don Evans comes up to my desk, the campaign chairman and later Secretary of Commerce, and says, "Well, I guess it's time for a recount. We better start mobilizing." And that's when you sort of take that last step into off the abyss into, what do you do now? We've never done this before. But one of the marvelous things about political people, even when there are lawyers talking to them, is they know how to react quickly under a crisis. And by 5:30 in the morning, people were on planes and flying out to Florida. And volunteers are calling up, and the world mobilized. I got on a plane at 10:30 the next morning, did sort of a flying seminar as we went into Florida, dropped people off in Tampa and Orlando and Daytona, and then I ended up in Tallahassee about 3 that afternoon, anticipating the arrival of James A. Baker III, who was taking over the recount. Now, the first thing you have to do as a lawyer in a recount is anticipate what's going to happen and what the field of play looks like. And the field of play in any recount and how we staffed it up was lawyers, because lawyers actually matter more in a recount than at any other time in a political campaign, let the truth be known. Political people, because Florida had 63 counties, and under Florida law there's counting going on in each one of those counties. You need communications people, because the running dogs of the media descend on you like a pack of wolves, to mix a metaphor. And logistical people, because you've got massive armies who are coming into the state. And in fact, within about 36 hours, there were 800 people on our side and their side who flew into the state to do this. Secretary Baker is frankly who we all want to be when we grow up in terms of legal skills and political savvy and just kind of savoir-faire about life in general. And he was pretty intense on getting a structure put into place that would be able to handle this. And so from a legal perspective, you got to think about the different issues. And so we broke it up in terms of a legal team to handle federal court issues, a team to handle state court issues, teams to handle each one of the counties because there was a lot of litigation down there, a team to handle what happens in the legislature, because the legislature can ultimately determine who the electors are for a state in certain scenarios, and people to handle the military ballots, because Florida was a state that was under a consent decree on their counting, or really lack of counting, on military ballots. And so within that broad federal structure, we needed to staff it up. As I say, there were a lot of volunteers who wanted to participate in what people kind of saw as a historic event. And so we really did have an outpouring. Now, in Tallahassee itself, we had probably 45 lawyers. I was about the only one who had a clerk for a Supreme Court justice at that point. So it was an awfully well-qualified group of individuals who came down, probably the finest law firms or mini law firms any of us will practice with, and we branched out into those areas. Over the course of the 36 days in Florida, there were 46 separate matters that were filed. We went up and down to the Supreme Court twice. We went to the Florida Supreme Court twice, and there was litigation in scores of federal and state courts around the state. A quick note on perhaps the most interesting issue that came up there as we dealt with it, and that was equal protection. Equal protection is, from really the McIntyre-McCloskey race back in 1984, sort of the wild card in litigating recount cases. In other words, are all similar ballots counted the same way? Because each county counts its ballots, they may do it slightly different. What's a hanging chad and counted in Palm Beach may be a pregnant chad and not counted in Dade. And is that fair under the law? Does it meet equal protection if all ballots aren't counted the same way? Now, just like really with the Voting Rights Act, Republicans have some fundamental philosophical difficulties with the whole notion of equal protection. And in this case, we decided, nonetheless, to begin filing the complaints based on equal protection. I was defeated in the Florida District Court down in Miami early on. It went up to the 11th Circuit. It sort of hung around there. It reemerged as an issue in the Florida Supreme Court cases, which ultimately is what went up to the U.S. Supreme Court. And at the end of the day, there was a 7-2 majority of the Supreme Court to find equal protection violations in the Bush versus Gore case. The justices split on the remedy 5-4, but there was a 7-2 majority for the notion that you needed to do something about the equal protection violations in Florida. Of course, Bush versus Gore is probably the most notorious of all the election law cases that's ever gone up to the Supreme Court. We did include equal protection as one of the core arguments in that case, and it was somewhat contentious as an issue, as the justices talked about it, Ted Olson for us and David Boies for Vice President Gore's squad. You all know what happened in the case. It turned out really going 5-4. We can, in the questions, deal with this a little bit more if you want. I think at the time, people were, the commentators were very adamant that it would set a terrible precedent for the future and really did harmful things to the Supreme Court as an institution. At the end of the day, Bush versus Gore has not been cited as precedent or binding precedent in any case in the 4 years since then. And I don't think you can credibly make the argument that the U.S. Supreme Court has lost any of its moral force because of that case. And so George Bush became president, and that indeed became kind of the mother of all cases. I think I should probably stop there and deal with any questions. I'm happy to talk about campaign finance or swift boat vets or whatever else may be on your mind. But I appreciate your attention in this. I hope it gave you some idea of what litigating in the law is like and how careers in these things can really sort of come up when you don't expect them to. The best way to get into it and to get into politics generally in a campaign is just to show up and volunteer. I mean, that seems like a difficult thing to do and a real long shot. But for those of you who want to get involved, the story of both the 2000 and 2004 campaigns is that people who came to volunteer because they were interested in it or felt it was important or both, and were willing to start off under the theory that no job too big, no job too small. I'm happy to make copies so someday I can write position papers for the president. By and large succeeded. And the number of people who came to Austin in 2000 or Arlington, Virginia in 2004, volunteering to do anything at all, and now have lofty titles and spacious offices in the Eisenhower Executive Office Building is really huge. And so I urge you to get involved and stay involved. It is a truly laudable pursuit and profession. So thank you. We have time for questions, or did I prattle on too much?
Absolutely. We have about 20 minutes for questions.
Okay, great. Yes?
I'm from Seattle, and I wondered if you had any involvement in the Washington governor's race in 2004 in the recount there.
I was counsel to the Republican Governors Association at the time. Dino Rossi, who I still think actually run that race, even although he's not really sitting in the governor's mansion today, was very conscious of Washington state sensibilities and felt that it should really be done with people who weren't involved in as contentious an election as Bush versus Gore in 2000. So many of us who had experience in that race were not involved, except from afar. But it was really a case where the whole equal protection argument, I think, might have yielded a different result had it been sort of uniformly applied. But what was your impression of it?
Probably biased, kind of the same way, but I don't know. It seemed kind of sketchy more than anything else that King County found 75 votes after 2 recounts.
Yeah, they kept on finding votes in the thing, and it ended up being decided by what, 100 or so? Yeah, but who's counting? Anybody else?
I'm just wondering if you think that the way that recounts are done now, or post-election litigation, whether it's the best way possible, or whether there's something, is it simply the best way that we're stuck with, or is there a better way to?
There might be a better way to do it. The problem that you've got is that it's still a matter of state law. And each state, as in so many things, has its own particular way of doing things and wanting to do things. So that you've got a real mishmash of statutes across the country, and some of them work better than others, I think. I think one phenomenon that we've gotten ourselves involved in since 2000 is election day litigation. Sort of the whole ballot security, ballot access, who's eligible to vote, the Help America Vote Act that went into effect. And you really, I mean, that's the litigation that I think you're now going to see a lot more of, as opposed to recounts. But that's a difficult and contentious area. The problem with it is that it's two sides of the racial divide coin in this country. Republicans think Democrats are going to steal the election and vote multiple times and cheat. And Democrats think the Republicans are going to intimidate minority voters from coming in and voting. And boy, you talk about two sides that can't see the other's point of view. It frankly is over that issue, which led to a lot of litigation and a lot of contentious feelings in a number of states. Ohio probably being the most visible this time, and Florida to another extent. Now, we had an idea for this time that Ed Gillespie, who was chairman of the RNC, proposed, which is if you think there's either going to be intimidation or fraud at a polling place, then let's get a Republican lawyer and a Democratic lawyer in each precinct where you think there's potentially a problem. And so if there is a problem, you got people on the ground who can deal with it and see it and kick it up the chain so there's some sort of sunshine cast on it and you can get a quick resolution to it. Now the Democrats refused that offer this time, which to Republicans meant that this is really a better sort of get out the vote issue for Democrats. In other words, if you keep saying that there's going to be intimidation, that's a way to get minority voters out in greater numbers. That they don't want a solution to the real problem. And Democrats said, well, we can't trust Republicans. You don't really care at all about minority voters. So I think we're sort of at an unfortunate impasse where there's going to be a lot of litigation going on in future years over those sorts of issues. Yes?
Do you think computerized voting, do you think that's going to help or just create more trouble?
I think on behalf of the Society of Hourly Billers, it's great stuff. In terms of the country as a whole, not so good. I mean, having been involved in recounts, I think it's really important to be able to see the ballots and touch them and go over them, as imperfect as that is. And this whole notion that there are computers out there that leave no paper trail and have no records, and there's no real means of verification, and there is at least anecdotal evidence and lots of conspiracy theories about how you can go in and mess around with programs, is not such a good situation to be in. Because you can really, I mean, think about it. If somebody gets in there and figures out how to maneuver a program so that for every 100 votes, only 3 are counted for a particular candidate or a particular party, the way the machines are checked on election day will never pick that up, because the test votes that are done always involve 50 votes of any permutation. And so you're just not going to pick up that stuff. And that's going to be the conspiracy theory that's out there. And the first time there's a close election on a touch machine without a paper trail, there will be a whole raft of litigation and doubts cast upon the election. I don't like them. I'm antediluvian. Yes?
Do you think that the equal protection problem also applies to the fact that different voting machines have different like error rates and things like that?
Well, I think that's a tougher argument to make, although I don't doubt for a second that somebody will be making that argument. I mean, that's a very good point. What the question refers to is that some types of voting equipment will have fewer errors if you run through 1,000 ballots than others. And so therefore, does that error rate tell you that the votes aren't, that there's an equal protection issue? I think that's a tougher claim to make, because I think on any of those machines of the same type, the error rate should apply uniformly to both candidates. I mean, in other words, if punch card ballots have a dozen errors per 1,000 votes, that should affect both candidates the same way, as opposed to the other types of equal protection arguments, which is you got punch card ballots in Broward County that are being handled and counted differently in Dade County, despite the fact the indentations on the ballot look the same way. So maybe, and I'm sure somebody will make that argument at some point, it's not as clear cut to me as the other type. Yes, sir.
What did you think of the initiative by Schwarzenegger for redistricting commissions, and what was the politics out there in California?
Well, the politics in California were that Governor Schwarzenegger thought that there was a political culture which the voice of the people and voice of reason would never be able to penetrate as long as the current redistricting was in place and you needed a neutral commission to draw a district. So in other words, take redistricting out of the hands of the legislature and put it in a commission. It was the same thing that Democrats were trying to do in Florida, Ohio, and Michigan. They lost in both Michigan and Ohio. The California redistricting initiative went down to defeat. The Florida one is about to qualify for the ballot in 2006, so there'll be a campaign over that too, probably. Personally, I think that commissions are probably just as bad and difficult, if not worse, than letting elected representatives who actually know the territory and the people draw the districts. Now, having said that, redistricting as a whole, it could be up for sort of a major change in not too long. The Tom DeLay redistricting, Texas redistricting map is a case that's been taken by the U.S. Supreme Court. And arguments are set for March 1st, so presumably there will be a decision by the end of June on that case. What's interesting about that case that they took is that it's got virtually every issue in redistricting. It's got mid-decade redistricting, which is sort of a small issue that would affect Texas, not really a nationwide issue. But it also has one person, one vote, it has Voting Rights Act, and it has political gerrymandering in it. Now, here's my great conspiracy theory on that, which really goes to the intent behind the commissions and those initiatives. If you're to look at the state of congressional elections today, if you're an incumbent, you don't lose. The re-election rates are hovering around 99.9%. If you read the Constitution literally, if you're an originalist, that's not what it's supposed to be. That the House is supposed to be the people's house. It's supposed to blow with the political winds going through the country. You can't objectively say that's happening today. Part of the reason that's true is that every decision that the U.S. Supreme Court has made since 1974, when they did one person, one vote, has screwed up competitiveness in congressional and state legislative districting. One person, one vote says that you got to draw weird lines in districts because it's the only way you can get equal populations. You can't enshrine communities. The Voting Rights Act has got the whole set of problems we touched on before. Political gerrymandering is not really constitutionally recognized under current Supreme Court decisions. So all in all, the decisions of the Supreme Court in the last 30 years have locked in 99% re-election rates, which is not the way the Constitution says the House is supposed to be. So they have the opportunity to remedy that in this Texas case that they took, which looks on its surface an awful lot like a case out of Pennsylvania they decided a year ago not to take. So that's an interesting way to look at it. Now the caveat for that is, back when I was, that's a complicated theory. The caveat for that is that back when I was doing redistricting at the RNC in the early 90s, I had a brain trust of great volunteer lawyers, and I did my best to come up with the best and the brightest in Washington to make me smart in a confusing field. And there was a case in the 90s, early 90s, that I also came up with a far too complicated theory to explain, and ran it by one of the members of the Brain Trust who had clerked on the Supreme Court and said, no, there's a lot less going on behind those robes than meets the eye. So we'll see if John Roberts, who was the guy who said that to me, if it turns out to be true that time. So that's the caveat to that great theory that the Texas case is truly meaningful. Yes?
What was your strategy going forward if Bush v. Gore had come out the other way? Where were you going there?
Well, the case would have gone back to the recounts in the individual counties. And at that point, we would have fought sort of tooth and nail to come up with really as applied challenges. In other words, we had massive evidence of the same ballot being counted as a Gore vote, but when it was a Bush vote, the same judges would not allow it. And so if we had to, what we would have done was proved that the election judges in the counties in Broward and Palm and Dade were jobbing us. And we would have just gone through the incredibly painful, both intellectually and time-consuming exercise that was there of showing about just how biased the individual counting judges were. And we had the evidence to demonstrate that. But it would have gone on for a long time, and it would have been very, very ugly. And so the court stepping in and saying, you got to bring some clarity to this situation, I think was right. And to the extent that we doubted that late at night when we were thinking about it afterwards, imagine if we had been in that sort of recount hell when 9/11 happened and there was no clear-cut president of the country at that point. So the notion of a Supreme Court jumping in a situation like that and saying you got to put some order to the chaos, you got to have cloture, you got to have a president, I think is right.
I'd just like to offer our thanks again. And,
Thank you.
Join me in giving a round of applause for your speech.
Thanks.